we're back on, it's 11:20. Let us tell you what articles we're prepared to TA on. And we're not prepared to sign anything today because I want to make certain that what we agree TA on is the same language that you think should be TA on. And since I told you that our starting point is we took the contract that was submitted for ratification, and we're looking for that language. So we would, want me to give you a list first, or do you want to tell me your answer as we go?
Well, I don't think my answer, I mean, what are you looking for, an answer, an agreement or a disagreement?
No, just whether, you would TA and work on the ratification agreement.
I thought I've already conveyed that in absence of the articles that we presented today in today's packet, that everything else that was in that bundle that was presented for ratification, that we have reached a TA on, that I have a date specifically attached to each article, that we were willing to move forward with considering those remaining as TA.
All right, we're on the same page then, but I do want to defer signing off on it. What I'd like to do is package up the things we say we're going to TA on, double check the language. So it would be Article 1, the preamble. Article 2, recognition. Article 3, non-discrimination. Seventh, union insignia.
About 4.
We're not prepared to TA on just one, 2, 3, 7. 8, 11, no individual agreement.
Hang on a second, let me record it. 1, 2, 3, 7, the one?
8.
7, 8, 11, 12, 14, 16 and 17, 27, 28, and 29, 33, 34, 36, 37, 38, 39, 41, 46, 47, 50, 51, 52, 54, and 55.
Okay, so do you have proposals on all those other articles? That we require?
No, but we will at the next bargaining session. I have a question though on 44. If you look at the language that they had when it was submitted for ratification. The second, got that? 44, comma time? Okay, the second sentence, this is the carryover from the first week of pay to the second week of pay at time and a half.
Second sentence says in accordance with.
Yeah, second and third, starting with the second sentence, read the rest of it.
in accordance with the Fair Labor Standards Act, extra work time may, under extreme circumstances, be carried forward from the first week of the paid period to the second week. Time off in the second week shall be 1.5 times the extra hours worked in the first week.
It seemed to us that your proposal on not extending flex time beyond the first work week would conflict with that language.
Flex time and comp time are two different concepts, right? So what's one have to do with the other?
Well, okay, let's suppose that I work a regular work week, and on Friday, I work 2 additional hours. Right? I believe your proposal is I can't move that into the second week.
Call it flex time.
Well, forget what you call it, I can't move it into this, I have to pay you in the first week for 42 hours, right?
No,
But if you look at this-
give the employee comp time at the rate of 1.5 times in the next week.
I could do it in the next week.
That's
But
correct.
comp time, I could pay at any time. Right? In the next work, I don't have to let you keep it on the books, I could pay you your comp time.
You have to.
All right. You don't think that conflicts with your flex time?
I know it doesn't. Flex time says that if you, I mean, I don't need to repeat the same thing over and over again. I don't see where the conflict is. If someone, if it's Friday afternoon, so if someone works on a 5-8 shift, they work Monday, Tuesday, Wednesday, Thursday, 8 hours. And then on Friday, they work 10 hours. You don't have the ability to flex them out within that same work week, so you are required by law to give them 2 hours of comp time.
Or pay them?
Or pay them if you want to, right? I mean, if you want to do it.
All right, maybe we don't need the comp time anymore.
Oh, we certainly do.
Well, maybe we don't think we need
Okay,
it.
you don't need it, that's fine. I mean, it's just basically spells out what the law.
I'm gonna pay it in overtime anyway. I'll just pay it on the first work week.
Yeah, because the comp time wouldn't be at sick time, it would be at time and a half.
So I might as well pay it.
I don't think you're gonna hear a complaint from an employee. Typically, the employer uses comp time to avoid paying, time and 1/2, but,
Well, it has the same value then, on the books, monetarily on the books.
maybe not necessarily operationally, but.
I can't pay Florida Power with comp time. I need cash. I can't walk into their office and say, here, I got 2 hours comp time, take it off my bill.
All right, we'll take a look at that.
It might be a matter of just having that first sentence.
Yeah.
Comp time is not permitted. Leave it at that.
Yep.
I mean, my understanding is Article 44 is just basically informing what the law is. I mean, it doesn't really, and I think it's useful. I think it's useful to have it if you read it.
I thought the second part of it was more, it seemed more like flex time to me than comp time.
Mhm. It's definitely a conflict with this proposal on it. It says weekly work schedule to avoid the accrual of more than 40 hours in work week. So it doesn't talk about the same thing.
Let's see if I have any other questions. We need to take a look at the workers' comp issue in a little bit more detail. See what you're,
Well, my understanding is that the proposal we have, not my understanding, our position is that the proposal we have for monetary tax practices would preserve something like that. And that just drives the point home all the more. I'm not sure of every policy and practice that the county has, and I don't think I'm gonna have the ability to know what every single practice is that the county has. There's a lot of departments that, may have certain things that they do, and so that workman's comp, monetary benefit would be something protected by the language we proposed. You want to invoke bargaining, you don't want something like that.
Our proposal and the language that we think is in the contract was, in the contract that was rejected by your members, would have eliminated supplemental pay. That's why I brought it to your
Yeah, the
attention.
contract that we rejected, I agree, or we rejected the contract.
But you TA'd on that article.
But we also have another article that protects, situations like that. And so, if you look at a proposal from today, which is what it is today. Which is 5, the very first page on page no, the very first proposal. Monetary benefits and past practices. I would believe that we would be, that we would prevail if we had agreed something like that being taken away. And,
I don't agree with that, because I don't think you could read Article 5 without reading Article 6. And Article 6 says the non-monetary provisions of the career service rules are applicable. So, I brought it to your attention because we don't want to reach an agreement with you and then have a grievance the next day or dispute over past practice.
well, if you don't take things away that you've been given all along, then I don't think you'd have a grievance. So, and I appreciate you bringing that to attention, but it just proves to me all the more reason why our Article 5 language is important. And whether you disagree that would protect that monetary practice or monetary benefit, that's your opinion. My opinion is that language would protect it and preserve it, and that we'd have to grieve it. And if we won the grievance, then the arbitrator, if it went to arbitration, would award. I mean, if we gave if we met all the criteria that's in Article 5, to establish that that was a monetary past practice, which I think we would be able to, then we'll be protected.
Well, that's why our original language on the past practice thing was, it said there were no past practices that are monetary in nature. Because it would have settled that issue without having to have a grievance over a past practice. But we compromised with you on that language, but maybe that's not the right solution to it. I still think it's our position that now, about almost 2 years into bargaining, that you should know what the monetary benefits are that your members receive from the county. And I don't think it is that difficult to figure out.
Well, then why don't you provide a list of them to me? You're the employer. You are the ones that offers these monetary benefits.
I have a list. If they're everything that is in the
There's
table
not
of
a list of
contents.
monetary benefits. That's a list of proposals. You're telling me that I should, after 2 years, be able to determine every single monetary benefit that's being offered by your client. And I'm asking you then if your client would provide me with a list of every single monetary
Let me be
benefit.
more specific. I think after 2 years, you should know what the benefit that your members receive when workers' comp comes in.
And I think after
And I don't
2 years,
think
it
you do.
shouldn't be too difficult for your client to provide a list of these
Well-
benefits that are in danger of being removed.
These are your resources right here.
I've been here 25 years and I never knew about that benefit because I've never been on comp.
Your code.
But now, yeah, but you need to find out what those are and explain to me.
Should my employer explain that to me? When I first come on a job, is my
Our duty,
initiate?
I'm gonna answer
Okay.
that. Our duty now is to talk to him about what your wages and benefits and conditions of employment are. It's not proper for us to talk to you about those things anymore. And we
So I
recognize
can't-
his authority to represent you in that interest.
So I can't go to my human resource director and ask her what one of my benefits is?
He's still an employee, whether he's being represented for purposes of collective bargaining or not. He's
You
still
can
an
ask for
employee.
data, you can ask for public information, you can't ask for interpretation or discussion about it. We have to do that with John.
I disagree. I cannot believe that you're taking a position that an employee can't go to the HR director and ask questions about what rights they have
I said they could get data, and they could get information, they can't
Sure they can, they
engage
go
dispute
in there
or
too, but why can't they
interpretation.
go to the human resource director and say, listen, suppose.
Because they're represented by you, and the law says we have to deal with you.
The law says you have to deal with me for the purposes of collective bargaining. This individual is not gonna go to HR for the purpose of collective bargaining. They're going there to find out what their rights are as an employee. I can't believe that you're saying that they don't have a right to find out what their rights are.
You're not listening to what I'm saying.
Yes, I
I'm saying
am.
they could go and they could obtain data and information.
I understand that,
But they can't
anybody
discuss
can.
interpretation.
Anybody can go and ask for an information request.
So
But you don't think it's proper that a worker can go to their HR department and ask for some clarification on what FMLA rights they have, or what benefits they have under their insurance.
I think they should go to
Of course
you
they
and
should.
ask that.
Let's stop it.
I think they should go to you and ask that.
Well,
I think that's what the union should be doing.
I think that's what the HR department is supposed to be doing, and I think if they were doing a lot of other things, we probably wouldn't be here.
The employees that have been on workers' comp know what they receive. I don't know what else you want me to tell you.
I don't even know what that statement means. What I am asking is
The people
how could
here
it
who
not
have
be,
been on
how could
workers'
it not
comp
be
have
permissible?
received that benefit.
How could it not be permissible for an employee to go to their employer and ask them what their benefits are? It has nothing to do with collective
Well,
bargaining. That is the duty of an employer.
Let's not take what I thought was a positive and turn it into a negative. I brought something to your attention because I didn't think you were reading it the same way we intended it. So I brought it to your attention. I didn't hang back and say, we'll just wait, it'll be gotcha, when it comes up. Okay, we won't be cutting the check for supplemental pay, gotcha, as the contract. I didn't do that. I laid it out, I identified it and said, here's an issue, and I'm just following up saying, I think you ought to look at that. And I do think you should use these people as a resource to do that, because we're two people here, we're discussing it at the end of the table about what one gets and said, I didn't know we get that. These are your resources too.
I understand that, but your opinion
But
is.
just
you don't
because
have
I've
the
been
right to
lucky
ask
enough
an
not to
employer
get
for-
hurt, I can't ask a question?
You just mentioned that you don't even think that it is proper for them to go to their employer and ask the question about what the benefits are. That's what you said, that's my job. That's my job to
I think
explain
they
their
should go to
benefits.
you to explain the
Right.
benefits
That's fine
that
if
they
they
have
go to me, but
as
I'm not their
bargaining
employer.
employers.
I don't employ them.
Well, then you could call and ask for some assistance in interpreting.
That's not my job.
What happened? I
My
got into a
job.
car accident. I got 14 days.
I'm not gonna deal with individual
I go to ask her a
hypotheticals.
question and she says, oh, you better talk to you, and all of a sudden I'm out of my workers' comp.
I'm not gonna we're not gonna respond to individual hypotheticals. We
It just
pointed out,
happened. It just
we
happened.
pointed out an article of the contract that requires you to do some research on it. And your members are a resource for that, and we're a resource for
I
that.
understand that, but I have a proposal, okay, and it's pretty close to being agreed to in front of me, that protects these members, these employees, in the event that something is going to be taken away from them later on. I have this language in front of me that's, so,
The language you proposed on Article
it's actually
Five.
language you proposed that I've commented.
on 5, is that what
On
you're
five.
looking at?
Right.
Okay, well, that's open, so.
I understand so, but even if it was accepted in its original, proposed format, even with it verbatim, it still would protect them. All it would do is it would trigger, bargaining, if you took something away and we agreed it prevailed, that you would, begin bargaining or demand bargaining over that particular, over the wage article. They don't have anything to do with wages, but, so what I'm trying to say is your language wasn't too far off from, what the union is requiring to have to protect us in such events. I certainly appreciate you sharing that, there may be more to workers' comp than I was aware of. I appreciate that. I just wonder what, since you won't quit talking about it, it seems like you're just trying to prove a point.
If you're talking, I'm sitting quietly.
I understand that, but you have repeatedly brought it up, and I appreciate you bringing it up. We're going to look into it, and I just feel very confident that our Article 5 language, again, will protect us. So anyway, let's move on.
Just so that you know, we think the Article 5 language just leads us into becoming a member of the past practice of the week club. So we're gonna want more specificity about monetary benefits in the contract and
So
encourage you to research what they are.
You're changing your proposal, right, you've already submitted.
I haven't given you anything, did I?
Not today, no. But I'm saying the language that you proposed that was good enough for the members to vote on, you're saying that
It was rejected.
it was rejected, right?
So I'm going back to the drawing board because it was
I
rejected.
understand that completely.
Okay.
So having known that you were going to not be willing to accept what we tentatively agreed to before, with all of these articles that were not, as an example, collateral documents. That's something I haven't, or management rights. We've already TA'd those in the past, but you are not, at this point in time, recognizing that tentative agreement, or apparently you're gonna have another proposal for it, right?
Well, are you recognizing that those are binding articles on your members at this
No,
point?
I'm saying that we're
Of
willing
course you're
to,
not.
no, but we're willing to agree to them, just like the numbers that you rattled off before. 1, 2, 3, 7, 8. We're also willing to agree to 4 and 6. We've already bargained over those, we spent time coming up with language that was, at the time, agreeable to us, and our position is that we're willing to TA that again.
That's what I understood.
So my point is, since you came here today knowing which ones that you were willing to recognize again as a tentative agreement, and knowing that there were several articles that weren't, do you have any comment to
Well,
that? Do you have any proposals to that?
First of all, you're wrong about what I came here intending to do. What I came here intending to do, and Barbara as well, was to listen to what your proposal was, because it was your members that rejected the contract. And I think that the both of us are a little bit disappointed that you were not able, since the time of rejection to now, to try to narrow down some of the issues that the contract may or may not have been rejected for.
I think
So-
we did.
That's exactly what we did with this list.
We think the list is pretty long considering, but be that as it may.
I think,
That's the only preconception of what we would do, was to listen to you, try to understand why you felt the contract was rejected. You know, we have our own belief about why it was rejected. In fact, we know why it was rejected, you lobbied against it. I urge your members to vote down the contract. But, you know, be that as it may, here we are. We're not, I told you what we're prepared to TA on today. And assuming that we have the right language on it, which I'll bring back next time, and I could send you a package beforehand so you could double check it.
yeah, it would be,
And we could start off the next bargaining session by initialing those, and then we can move on to the other articles that are open.
well, just in rebuttal to what you just said, I think we've backed off.
You can't rebut it, it's my opinion.
I can rebut anything I want to.
Okay.
And so, in response to your opinion,
Okay.
I'll just share my opinion. And my opinion is that we have backed off substantially from our initial proposals, specifically in the arena of seniority rights. That we scaled things down, you have taken out numerous pages of disciplinary language that, was going back and forth for months. You've just taken it all out, and we've accepted that. I think we've made a lot of movement, maybe you disagree with that, that's fine, but, we have a lot of people please on our side, and you don't have as many. So we, the point I was asking is, it would be natural for me to expect, and it is natural for me to expect, counter proposals on things that you already determined, unless what you're saying is you didn't know that this list that you gave me, or this list that you gave me of things that you're willing to TA, that list didn't exist prior to us submitting our proposal today? Is that what you're saying? In other words, the numbers that you gave me, those weren't thought out until after the beginning of today's bargaining session?
Well, how we prepare for bargaining is our business.
Well, I understand it's your business, but.
But I can tell you that during the caucus that we just took, we went through the contract, looked at the articles that you said you wanted to talk about, and I marked up today, small little dot, all the ones that we were prepared to TA on. All the other articles, we consider either to be monetary or somehow tied to or triggered by articles that you have open. So they need to be open until we get a contract, or narrowing down bargaining session by bargaining session. You could paint your effort any way you want, but it's patently absurd for you to, with respect to Article 9, union dues deduction, not to acknowledge that $2 is a nominal and reasonable fee for administering dues collection. That's just a principle point on your part. That's fine, but the statute says we're allowed to collect something, and the movement was $2 is just to say we collect something. It costs us more than that to do it. We're certain of it, but that's not good faith in our point of view for you to have done that.
That's not good faith, they did not take what you're giving out.
I think what would be good faith
So
for you to say, we'll give you $2, even if it just came out of your pocket just to pay the $2 and take that off the table.
Agree to the $2 and have them give us the $1 an hour raise. Yeah, we're negotiating. You give something to us, we give something to you.
Senior new lead negotiator?
This is helping out. It's just absurd to think that because we don't accept your proposal, that's not good faith. I think that's absurd because of all the articles we
All
put
right,
forward.
so what's your dollar amount on dues deduction? It's something between $0 and $2.
What about seniority? What if you come back with seniority?
No, I'm not asking you about dues deduction. Take
Well,
one article. Just give me a
one.
response on one article. We're only $2 apart on this article, okay?
And
You
if a lot,
can't find a counter proposal that'll settle this article today?
you can't find a counter on wages or seniority that is remotely close to what we're looking for? Because, don't go ahead again, that's ridiculous. For you to say that $2 is preventing us from having an entire agreement is absurd. That's
I
not
didn't
what
say
the
that.
issue is.
I pointed specifically to one argue and said we're only $2
I think
apart on that
what is-
argue,
I think what
and
is
you won't even
absurd
offer a
is that-
compromise on
Is
it.
that we've reached tentative agreement, I would venture to say a dozen articles that you don't want to TA today. We've already.
You rejected them. Your members
I
rejected
understand
them.
that, but we
You
told
can't
you.
give me a list of what your members voted on article by article, so I have to treat them as though they're all rejected.
I came today with a list, and before I gave you the list, I said that we're willing to TA everything other than is what is being presented to you today. Didn't I? I did do that, didn't I?
You did.
So then I gave you a list of what was satisfactory and what was not satisfactory. I explicitly spelled it out. And so that's what I think is a waste of time and effort when we spend a significant amount of time talking about union visitation as an example, why it was good the day that we TA'd it and why it's no longer good today.
All right.
When it has nothing to do with a monetary issue.
Okay. One thing I'm certain of is what's a waste of time, and that's continuing our discussion today. We'll get back to you with additional bargaining dates.
How about providing them now?
We can send me dates that you're available on
How much time do you want to have in between today? I would like to get back. I got the first full week of March wide open.
I'll send you my available dates. How about that? Can't do it without me, so I'll send you my available dates.
All right, I'll wait to hear from you.
Say it, continue.
This is just to sit here.
He can't, hey, he can't.
Wait, and